proceed in the matter of InterDigital Technology Corporation and others, and Lenovo Group Ltd and others.
Sorry to have kept you all waiting. We had a problem with the power in the previous.
I understand. Not at all, my lord. As my lords and my lady know, this is an appeal against the decision of Mr. Justice Mellor in a telecoms trial. It's one of several telecoms trials in the InterDigital Lenovo dispute. This one's known as Trial B. The trial took place in June 2021 and resulted in the judgment under appeal, which is in tab 8 of the core bundle, which is dated the 6th of January 2022.
Yeah, you can take it that we've read the judgment, we've read the skeleton arguments, we've looked at the patent in suit. Speaking for myself, I find the jargon extremely difficult to understand, so you'll have to take the more technical aspects a bit slowly so that I can keep up.
I'm going to try and do that. Can I start by just pointing out something that is quite notable about the judgment? It's notable that the judge both expressly rejected all the various ways in which Lenovo argued that the particular prior art relied upon, referred to at trial as filiatro, was contended by Lenovo to anticipate, but in a separate and additional part of the judgment, he held precisely the opposite, that filiatro did not anticipate. And can I just start by showing you that? Firstly, his conclusion rejecting all the ways filiatro is said by Lenovo to anticipate. The anticipation section of the judgment is something that starts at paragraph, so I'm in tab 8, it starts at paragraph 254, it's internal page 62, bundle page 140.
Yes. That's
where the section starts, and it's quite a long section. It culminates at para 301, bundle page 153, just above the top hole punch before the heading obviousness. And my lords and my ladies, see the judge there saying he's rejecting all the various ways in which Lenovo argued filiatro anticipated.
Well, not quite, because at 253, he refers to the case based on DXX14. So you're quite right that in the section of the judgment you just referred us to, he's rejected points A, B and C, and then he comes on to D.
Indeed.
Later on.
My point of showing you this split structure is that at the core of my submission is he's actually applying two different constructions.
Yeah.
And so I wanted to show you that he's dealt with what he says is all of the grounds, but my lord's quite right, he comes back to a different point later, and that's where I was going to show you where he holds the opposite at 323. So in internal page number 79, bundle page 157, where he holds that the claim is anticipated. And as I've just foreshadowed, my submission that he's in fact applying two different claim constructions at these different points in his judgment. Now, my learned friend argues that he's not doing that, not applying a different construction at that earlier point to the one at the end. And I'm going to come on and address that. But what I do point out to my lords and my lady at this stage, it's notable that my learned friend doesn't actually support the judge's construction. And by that I mean the construction.
As his primary.
Indeed. He doesn't support the judge's construction, and by that I mean the one at the end, as his primary case, as my lord just pointed out. His primary case is a construction which he raises by respondent's notice, which he raised before, which the judge rejected. But it is notable that neither of us are very keen on the judge's construction, if I may put it that way. And as I shall explain, and I hope to demonstrate, my construction is actually the construction that the judge was applying earlier on. But to keep things clear, even though I say the judge was applying it earlier, I'm going to keep the labels that you, my lord and my lady, would have seen in the skeleton. So we're going to have InterDigital's construction, which I say the judge applied early on, Lenovo's construction, and the judge's construction, by which I mean the one at the end, to be absolutely clear. Now, the route map of where I want to go First, I want to explain the technical background to try and hope to assist my lords and my lady to understand the context into which the invention was made. So the first bit of my submissions are not focusing on the invention. I'm trying to explain how, for instance, UMTS worked, what the proposal had developed to for the enhancement, which turned out to be something called HSUPA. Basically what the judge referred to as the prior specification. Then I'm going to explain the contribution made by InterDigital and the patent. I'm going to explain what it does, how it compares to the prior specification scheme, and how it was understood and treated in the materials filed before trial, including by my friend's expert, and as I've said, indeed by the judge in the earlier parts of his judgment. Then I'm going to address the DXX14 cross-examination document and show my lords and my lady how it came into the case and what it illustrates about the prior specification. Then I'm going to point out a non-infringement point, which hopefully my lords and my lady will have gathered the judge thought had some significance. He basically thought it gave rise to a squeeze, but it doesn't.
Gave rise to a
squeeze.
A squeeze, yeah.
That's what he was doing. He decides the point against my friend, but then says it has consequences later. But we say it doesn't, and indeed, that's why my lords and my lady have got 3 constructions before you, because it isn't a squeeze, they're just 2 different dimensions. Back to my route map, I'm going to turn to the patent text next, say a little bit about the examples, and look at the detail of the claims and the 3 constructions in play. But of course, I will have foreshadowed key aspects about the rival parties' constructions before then, but I'm going to focus in on it at that stage. As I go through all of the matters, I'm going to deal with many of the points raised in the skeletons, like the suggestion my construction is new, that I had a different case at trial, something that's quite wrong in my submission. And then I'm quickly going to run through the points advanced by my friend as to why my construction's wrong, just to make sure I've pulled everything together so that my lords and my lady make sure that you've got my answer to everything. And I will also address the suggestion that infringement is avoided on my construction, or somehow there's a point not addressed by the judge going to infringement. And then finally, right at the end, I'm going to say a few words about the point advanced in my friend's skeleton about the means for integers in the claim simply meaning suitable for. That is in fact the only thing that's new in the matters raised on this appeal. It's quite misconceived. I'll explain why. At this stage I'll just say it's notable that it doesn't support Lenovo's primary case at all. So with that introduction, can I turn to the prior specification, the system as it stood before the invention, and I'm going to try to cut through the jargon, but I'm still going to have to use particular labels and hopefully make my lords and my lady see what matters and what doesn't. You know that the technical context of this case is UMTS. That's the 3rd generation of mobile telephony technology, and in particular an improvement to that standard that was developed sometime after its initial release in the early 2000s. We're concerned with work carried out in 2005 on an improvement to it, and the improvement became known as HSUPA. Don't worry about what that is, other than to know it's about an improvement of the performance on the uplink. The U in that stands for uplink. And that's a transmission, obviously, from the mobile up to the network. And the development, which was called enhanced uplink at the time, had been started, but the work was not yet finished. And my lords and my lady know that the invention concerns a detail that was introduced at InterDigital's suggestion. Now, at the priority date, which is the end of April 2005, the proposed enhancement had developed in a specification document that was referred to at trial as the prior specification. And in fact, the document relied upon to mount the anticipation attack, and indeed the obviousness attacks actually, was the latest incarnation of that. It was a markup of the prior specification distributed to those involved in the work a few days before the priority work. And it's simply called Filiatro at trial because it's the name of the person that did it. The prior art is the as then latest version of the prior specification, and there was a large dispute at trial, but no longer live on this appeal, as to how that prior specification operated. And basically the dispute was resolved by the judge preferring my expert, Mr. Townend's evidence, over Lenovo's expert, Dr. Irvine. As it's now common ground, I'm going to just explain the key aspects of how it works. First is that UMTS is something called a CDMA, or Code Division Multiple Access System. Now, I know my Lord Justice Arnold has had to get into that and its consequences in other cases, but my Lord and my Lady will be pleased to know we don't need to get into the niceties of how mobile phones in a cell that are all transmitting at the same time on the same frequency can do it so that at the network they can untangle the individual signals.
Yeah, just remember that unlike Lord Justice Arnold, I'm a novice in all this.
Me too.
You don't need to know how it works. It's a kind of system. It can be done, but the key thing is there's a limit on how much information can be sent across the airwaves in this way. The power of the transmissions of each individual mobile has to be tightly controlled, and the overall power of all the transmissions viewed collectively has to be maintained below certain levels. And you can think of it this way. Each mobile's transmission is in fact a contributor to noise that each of the other mobile's transmissions have to overcome to be heard at the network. So one has to control the overall amount because the transmissions from all the other mobiles is noise, or any individual mobile's transmission. And what you do is you exercise this control by controlling the amount of individual power that the mobiles use to transmit. You're controlling power. An additional thing you need to know is that power and the amount of data being transmitted are often considered interchangeably, because to send more data, a mobile needs more power for its transmission.
When you say power, you're not talking about electricity, are you? You're talking about radio...
Well, I'm talking about the power of the electromagnetic wave, yeah. But it's kind of. But the key thing, actually, that I'm getting to, my Lord, is that I've taken it through power to then data. The key thing, when you put those two together, and what you'll really be focusing on going forward, is that in a CDMA system, you have to tightly control how much data each mobile can send.
But to answer my Lord's question, the two go together because you use less power in the electromagnetic spectrum, and that has the beneficial consequence that you use less battery power from the mobile as well, which you also want to achieve.
That is true, although the key thing that requires the precise control is the noise point. But yeah, my Lord's absolutely right. It has a knock-on effect that if you can keep it down, it has an effect on battery and the long life between recharges and so forth.
And it's not a question of capacity to transmit more of the in respect to the individual mobile. It's a control of its data sending.
Exactly. You can, and I'll explain, but you can give an individual mobile an ability to send more at a particular time, because it can. Yeah. But you can't let them all do it.
Yeah.
There is an overall amount that is physically impossible to get over the airwaves. And actually, that's why we sometimes refer to the air interface as a resource. It has to be shared out. So, and what's crucial is looking at what all of the mobiles, say, in a cell are doing. And as I just said, that's why the air interface is a resource shared out between them. And as I hope my lords and my lady have understood, it's this overall level that you're really worried about, because if you get to a higher level in the cell from all the phones, you've got a problem with any one of them being heard. But the way to control the overall level is individual controls on the group. Now, the next basic aspect of UMTS I need my lords and my lady to take on board is that transmissions are made in a given time window or intervals. They're very short in human terms, just a few milliseconds. But when I speak about controlling what mobiles in a cell send, I'm talking about in an individual window, because they do it again and again in a series of intervals called TTIs. Of course, if you're quick about it and know which mobiles need what in terms of resources, you can reallocate how the overall resource has been shared out between mobiles TTI by TTI. And that's where the grants come in, and I'll come to that. But you've got a particular TTI where you may have shared out the maximum in the cell a particular way, and that may change for another time window when the mobiles are transmitting another set of data. So you're worried about it TTI by TTI. Now that's the basic points about UMTS in general. Can I pick up my summary of where the prior specification for enhanced uplink, the improvement had got to? What I'm particularly doing is picking up what I run through from paragraph 15 of my skeleton. So I'm still describing the context into which the InterDigital's contribution is made, but particularly focusing on the prior specification for this improvement. The scheme for enhanced uplink was to introduce a new channel. So it's a logical thing that data is sent on, called Enhanced Dedicated Channel, or EDCH. My lords and my lady will quickly pick it up. Everything that's being introduced has got an E shoved in its name somewhere, and E always stands for enhanced. So EDCH is a new dedicated channel, called EDCH. And the way it's achieved is you have a new logical entity in the protocol stack. That's simply the programming that carries out the manipulation at different levels logically. It's part of an existing entity called MAC, and it's a new part of that, and it's called MAC-E. And it constructs packets called MAC-E PDUs that are transmitted on this new channel, the EDCH, in each TTI. And what the process involves is the entity, the MAC-E entity, taking packets that have been assembled together by another pre-existing MAC entity, happens to be called MAC-D, and it takes those MAC-D packets, which are called MAC-D PDUs, as is the convention, and puts them together, sticks them together in a process that's called multiplexing. So if you take a packet from another entity and sticking them together, that's called multiplexing, and we explain that in paras 16 and 17 of the skeleton. Here's the time to pause to point out an important point that's in our paragraph 16 that I've just described. Taking a MAC-D PDU and multiplexing them together is a process of taking discrete chunks or blocks. It's not a continuous stream where you can take as much as you like. It's packets that are already there, and you've got to take another one or none at all. So you can keep taking them, but you must always take one or nothing.
So you're repackaging packages.
You're putting the packages in a bigger package, absolutely, but you're not allowed to start chopping the smaller
Original
packages up.
ones.
Exactly.
Up.
and you'll see a picture in a minute that shows that, but that's exactly what you're doing. But the MAC-E entity either takes an additional smaller package or it doesn't. And just so that you understand, sometimes that smaller package, which is the block that must be used, is sometimes called a multiplexing block, particularly when referring to their size, because it's the thing that has to be put in when you're multiplexing. And this, using it in discrete chunks or blocks, causes some of the effects that we will need to be concerned with. Has my lady got a...
It's stopped, that's all.
Oh.
And I'm not sure what to do about it. Ah, it's now going again. Sorry about
Back
that.
on track. Not at all. Now, the way the air interface resources were shared out in the scheme in the price specification was to have separate allocations or grants for each mobile for different categories of data. There's a single scheduled grant, sometimes called a serving grant, and there's a category of data to which that allocation applies, known as scheduled data. And there were a multiplicity of separate categories that were collectively known as non-scheduled, to which separate non-scheduled grants applied.
Now, the judge gives a partial explanation at 118 of these expressions, but I'm afraid I'm still a bit unclear about what's the difference between scheduled and non-scheduled.
Right. At the moment, you just need to know that data is categorized actually at several different levels, but there is this high-level dichotomy between a type of data that is referred to as scheduled and a group of categories that are non-scheduled. The non-scheduled ones are actually typically the type of data which may be particularly urgent. An example...
Non-scheduled.
Non-scheduled. It's slightly counterintuitive. And let me just explain why that is. The non-scheduled grants don't change so rapidly. So you'll have a grant that might enable your device to be doing a VoIP call, because a VoIP call needs to send a relatively small packet but regularly, or a small amount of data regularly. And so you may have a grant that is specific to that kind of data, which will be one of the non-scheduled ones.
It perhaps should be explained that VoIP is Voice over Internet Protocol.
Indeed,
So
it's a way of...
It's sending conversations over the internet.
Yeah. And so rather counterintuitively, the scheduled one is actually the one that changes rapidly and is likely to be of a larger volume, because if a phone's got, say, files that it needs to send up, it may ask for an allocation and be given it. But they are both controlled by grants, and there is this categorization which basically provides for phones to have an allocation of sending some kinds of data at one level and a separate allocation for different categories of data. Now, I've just at the moment described them as categories of data. What one sometimes sees in the papers is they're referred to as MACD flows to which they apply. So that's just the grouping of the MACD PDUs that are coming down the line, which have that category of data in it. So you might have the category that have got the VoIP packets in. That'll be a MACD flow. That'll be a non-scheduled one. And then you may have a broader one, which is all the scheduled ones. All I want, my lords and my lady, to take from this is that the MAC-E entity could take MACD PDUs from different sources in the MACD flows, from the different MACD flows, sorry, in accordance with separate grants or allocations. I can only use so much for the scheduled category, I can only use so much for a particular non-scheduled category, and so forth. And you can continue to take MACD PDUs from the relevant MACD flow and multiplex them in to the data until adding a further one would exceed that particular allocation or grant. So they're separate allocations or grants to different categories. And that's basically the way the prior specification worked. Now, the next thing I want my lords and my lady to understand is the fact that what actually gets sent, so what's handed to the physical layer and sent over the airwaves, has to be in one of a limited number of electronic containers known as Enhanced Transport Format Combinations, or ETFC for short. And what you've got to understand about those is simply this. Not the detail, but they're basically boxes of particular sizes, and you've got to use that box of that size. It's as if Amazon have got a limited number of boxes. They've got to send whatever they've put together out in one of the boxes.
Well, that was an analogy that occurred to me, but I'm told it's not very helpful.
It's well, it depends.
Up to a point.
You're both right. But
And you choose the box, Amazon will choose the box after it's assembled what it wants to send, and otherwise you might have to choose the box and then...
exactly. Well, that's what we're going to get into, is whether you look to box sizes first or whether you stick it all together and worry about the box size at the end. What you need to know is that they're limited number, they're of increasing size and generally increasing gaps between them as they get bigger. And also only some of them may be available to be used at any point in time. And the process of restricting which ones are available is known as ETFC restriction. And you'll see that in a little bit. But there's a kind of theoretical, here are all the ones that we make available, and then the phone has to go through and work out which ones are allowed at any particular time.
And so the availability at any one time might be restricted.
It may be restricted, and that's before you even look. So that's an earlier process.
Yeah,
but
exactly.
Now, as a general matter, hopefully my lords and my lady will have grasped that the data that's multiplexed by the MACI entity won't precisely fit an ETFC as a general matter. You may be very lucky, but generally it doesn't. And what the approach was in the prior specification is this. After the data is multiplexed, the nearest larger ETFC is identified and the remaining space is filled up with padding. That's explained in our skeleton at para 21. And this perhaps may be one of the reasons that my Lord Justice Arnold is alive to the fact that it's not a great analogy, because you actually do add the bits. It's not just space in a box. You add bits so that the thing is the right size.
So do Amazon. Lots of it.
Different bits. But you add bits. And padding is a series of useless bits that are added to make the total the right size. And they're discarded at the other end. So they're actually there, but discarded at the other end. So the key thing is this: padding, no informational value, but, and of course this is crucial, it does contribute to the noise, does contribute to the overall using up of the air interface resource. And so when one looks across the cell, the overall number of bits transmitted in the cell across the whole population, you know that it's limited for the reasons I've explained. A proportion of that limited number is in fact a quantity of bits that are useless. So the invention's all about trying to reduce that proportion.
That waste.
Yeah. because you can't go above that level because of the noise restriction, but if you can reduce the proportion of padding bits, you're basically getting a better efficiency out of your cell.
Well, you're improving the signal to noise ratio, in essence. I mean, that's probably a crude way of looking at it, but that's the effect of it, isn't it?
Is it not quite, my lord, because the signal to noise ratio is, I think, a physical thing that is a measurement on a particular signal. What you're actually doing,
conceptually,
you're improving the proportion of the use of that limited number of overall bits, which are actually useful bits that you want to send.
Yeah.
So,
yeah, a bit wasted is a bit wasted.
Exactly. A bit sent that's using up, say you can only send 100 and 10 of them are padding, but you can change it so that only 5 of them are padding. You're getting 95 bits across every TTI instead of 90. You're increasing the data throughput in your cell. And that's what the invention does. And let me explain what the invention is. I'm moving now. Hopefully, I haven't lost, my lords and my lady. You understand the basics of what's going on. And what the invention does is to contribute an idea of adding a step of limiting the total data that's multiplexed using the size of an ETFC that I shall refer to shorthand as next smaller than the total allowed by all the grants. What I mean by that, and in fact it's set out in longhand in the claim, next smaller is the largest that is smaller. So you've got to go to a smaller one, but you're only going to the next one down. So there's an amount of data that's allowed by the totality of all the grants. That is an amount of data. And what you're doing is looking to the ETFCs that are available, and you go down to the next smaller one, and you use that size as a limit on the overall amount of data you can multiplex.
In that TTI?
In that TTI.
Does that mean that some data might, so to speak, have to wait for the next TTI?
Absolutely. Absolutely. And you'll see that in some of the diagrams. That's absolutely right. And you might think that's a counterintuitive thing to do because you're getting less for that phone. But overall, you end up with, well, I'll explain how, but you end up with less padding across the cell.
Yeah.
But you are absolutely, my lords, a nail on the head, you are restricting it in a way that you wouldn't otherwise be restricting it. You've still got the grants that apply to each category, but you've got this overarching limit that you apply on top, and it's lower than the sum of the grants.
So you get 2 boxes instead of 1.
No, you don't get 2 boxes. You get a rule which you have to comply with as well, which in fact might result in 1 box instead of 2. But hopefully my lords and my ladies see what's going on. You've got this extra rule, which is a limit on the data that's multiplexed, and it's actually a limit that's set by looking at an ETFC size. And just before I go any further, what you're basically doing is setting a limit on how Amazon can stick together what's going to be delivered by looking at the boxes they've got available, even if it means something might have to wait to another box. And so what you have to do, remember, in the price specification as it stood, you just multiplex together using the grants, and then you look to the ETFCs. And you have to find one that's big enough. Do it after multiplexing there. What you have to do is look to the ETFCs to get this value, which you use as a limit in multiplexing. And as I've said, I think it's across all the categories, so in that sense it's overarching. It's a word I'm happy to continue to apply, contrary to my friend's suggestion, And it never ever meant across TTIs. It was ever meant across all the categories. And as I've said, the number that you're using for the limit is the size of the next smaller to the total amount that is allowed by all the grants. And if you just stop and think about it, what this does, it ensures that the resulting body of data that the MAC-E entity multiplexes fits into an ETFC that is no bigger than that next smaller ETFC. Ensures it's no bigger. There may be reasons why it's actually smaller, but what the step of applying the limit of that ETFC size does is ensures that a bigger ETFC is not used. I'm applying a rule that ensures a bigger one is not used. Can I make a few important points about that? One is to pick up a point my Lord Justice Lewison just made. Ordinarily, that may well lead to an individual device sending less data than the scheme before the proposal. So you might view it in isolation as not a good thing, although you might ameliorate that somewhat if the grants, as a consequence, can be set a little bit higher. You may, but ordinarily what you're doing is imposing a rule which means you might have less data that can be sent. But secondly, and importantly, across a population of mobiles, say all those in a cell, it increases efficiency if you're looking at those across the population over time, so statistically. And it does so for this reason. If you're operating in a round-up scheme of the prior specification, to borrow a label that Dr. Irvine used, where one multiplexes first and then looks for the next biggest ETFC to accommodate the resulting packet, one might very well end up with a MAC-E PDU where the space that's filled with useless padding is bigger than the multiplexing block size. It could be bigger. Remember, you've taken each category and multiplexed the blocks into the PDU until you can't add another block without exceeding each individual allocation. And then you look for the next larger ETFC. And that excess space may be bigger. But if you round down to the next smaller, for multiplexing, and restrict the data multiplexed across all the categories to that size, one generally should not be inserting padding greater than the multiplexing block size. What that means is across the population, all transmissions in a cell, statistically, which you're actually concerned with, generally less useless noise contributed by padding. And that's why the invention gives an increase in efficiency, a smaller fraction of the transmissions being taken up with smaller fraction of the transmissions being taken up with useless padding.
And that's the means for limiting, is it?
The means for limiting is basically something that applies the rule that does limit.
Yeah.
But the new rule that has been introduced, I'll come to it and I'll explain that the invention is basically a procedure. It's claimed in apparatus form and method form, but the means is just the apparatus way of identifying the step that the procedure has to have.
Yeah.
And it has to ensure that that bigger ETFC isn't used.
Well, can I ask you another question now? Because I don't think I quite understand it. One of the points that Mr. Abrahams takes is that, well, this procedure doesn't always apply, and he says it could not apply in 99 cases out of 100. But what is it that triggers the application of the rule, so that sometimes it's applied and sometimes it isn't?
Well, I'm going to come on and cover that, but if my Lord's question is what in the real world in the standard causes that, it's whether or not you are in the special case of having only the non-scheduled data.
Yes, I think the judge makes that point when he's discussing the interpretation of the claim.
Yeah, but so if you've got the special case where you've only got, say, the VoIP data and maybe something else which is non-scheduled, where you, and I'll explain why, for particular reasons, you do not want to restrict time-critical data at all. So if you decide to opt a mobile out when it's in that situation, in real life, it doesn't do this because it doesn't apply this procedure.
So that's a function of the standard rather than the invention.
Yeah, exactly. It's a function of the standard. And to cut to the chase, my lord, the fight on this is whether the invention requires all phones to do it in absolutely every TTI, or whether you're entitled to say you're working the invention, even though in some TTIs you may opt out for a particular reason where there's some other more important reason that you don't do it. And I will cover that, but that's how that dispute comes in. It comes in because in real life there is a situation where a phone won't do it, so the means that are in the phone are just not deployed on that occasion, and it applies a different rule. I mean, in this case we're talking about means, but obviously it's always programmed logic that does it, but the programmed logic that does that is not deployed on that in that TTI. But it is there, and it does it on all other occasions. And the real crux of this fight is the judge has construed it to cover phones where it's not there and never does it. That's the case in a nutshell. I'm rather jumping ahead. Now, the increase in efficiency relating to the use of padding is a benefit recognised by the judge and indeed common ground before the court. Let me just show you that. For example, look at my friend's skeleton, paragraph 26. Paragraph 26 of his skeleton, so it's on page 8 in the middle.
Yep.
He agrees with the way both our expert and our skeleton explains the invention, particularly, please note this well, to ensure that an ETFC larger than the sum of the grants is not used, refers to footnote mentioning the benefit, less padding, and also refers to the judge recognising increased padding efficiency. My learned friend also comes back to it in paragraph 31, where he refers back to paragraph 26, and specifically agrees with our explanation that the efficiencies are achieved over time across populations. Common ground.
Yeah.
Next point I make is something that I've already foreshadowed a little bit, but I really can't overemphasize it. What adding this step to the procedure does is ensure that mobiles operating in accordance with the new procedure create a MAC EPDU that will always fit in an ETFC that's no bigger than the next smaller ETFC size. In other words, ensures larger ETFC size is not used. It ensures the larger ETFC size, which, as I've explained to my lords and my lady, bring with it a likelihood of a higher proportion of padding. It ensures that that is not used. We explained this at paragraph 58 of our skeleton in one of the passages that was mentioned in my friend's skeleton that we just looked at. Now, there was a convenient illustration of the difference between the scheme prior to InterDigital's innovation and with it added in. It was a corrected version of a diagram initially put in by my friend's expert, Dr. Irvine, and it was referred to at trial as X3. The judge set it out at para 195 at the foot of the page, and it's in our skeleton at 29. I've brought larger copies along because if my lords or my ladies' eyes are anything like mine, reading the text is not so easy where somebody's put a landscape diagram in a portrait configuration. Could I just hand, it's the same thing but just easier to read the text.
Even with the aid of a magnifying glass, it wasn't that easy.
Well, but when I was looking at it, putting my note together, I realised that when I want to say you can see what's happening at step 3, it's not so easy. So I thought I'd bring along, it's exactly the same thing. Now, what you see here is illustrating the general position where there's an amount of data that would be allowed by the total grants. That is shown by the red dotted line. So the arrow going out, the black arrow going out to a point where you've got a red dotted line. That is indicating an amount of data, total amount, that would be allowed by the total grants. The judge explained that Mr. Townend explained that one doesn't actually add them up in the prior scheme. That's just for my lords and my ladies' note, that's paragraph 197 and 198. Where it accepts the qualification, but says it doesn't matter to the point being illustrated. And he's right, but it's important that you understand that you're not actually adding them up in the prior scheme, you just use them individually. But there is an amount that the grants that are there correspond to, and it's that red dotted line. And we see, so I'm on the left-hand side, multiplexing carried out at stage 2. We see the grants are used at that point, as we've discussed, and that gives a quantity of multiplex data shown at step 2. And my lords and my lady can see the individual multiplexing blocks, which come to a size. There's actually a smaller one on the front, which is the header. But you've got those individual multiplexing blocks. And it comes to a size that's actually a bit less than the dotted red line. And that's because of the feature that I pointed out to my lords and my lady about you've got to take individual boxes. You can see if you put another one in, you'd be over, so you can't.
Carry on turning the cards till you get to 21.
Yeah, and then you find you've gone, yeah, exactly. So you use the grants, and you have to stop at each grant, and that will mean that you are necessarily at some level below. Bit less than the dotted line, but here you've got 4. Then at stage 3, so after multiplexing is done, we have selection of the ETFC to use, and that's one larger than the multiplex data. You've got to get one that will get that body of data in, so you go to one larger, and it's highlighted in yellow in the diagram. It's ETF number 5. And step 4 is the addition of padding, the shaded region, up to the ETFC size. So the general result is an ETFC bigger than the dotted red line, which is the sum of the grants. And depending upon how far out to the right that ETFC 5 might be, as I've explained, you've got a risk of actually the padding being significantly larger. Now that's the scheme in accordance with the prior specification as it stood before InterDigital's contribution.
But
Now,
before you go on, Mr. Speck, that means that the padding takes you over the dotted line and you've got more than the grant allows.
yeah, and the grants are set for that, with knowing that that's going to happen.
Okay.
It gives you more than the sum of the grants, absolutely. But the key thing is you're going up to an ETFC size, which may actually mean that the size of that padding on the whole might be bigger.
The grants apply either to scheduled or non-scheduled data, and the padding is neither.
Neither.
So you're not infringing the grants by
Exactly.
Packing it
And,
all up
and,
together.
and you set the grants knowing that this is how it works, so that there's going to be an amount of padding when it all comes out statistically. But you're infringing neither rule because, my lord's right, padding is neither. Now, the scheme in accordance with the patent is shown on the right-hand side, and it's intended to show basically the phone with the same grants and the same ETFCs actually available. So that's what's depicted. In this modified procedure, before the multiplexing is done, an ETFC is identified. It's the biggest that's smaller than the sum of the grants, so what I've been calling next smaller. And obviously to do that, you do have to add up the grants because you don't know where that red line position is. So you do have to add them up and identify the ETFC so that you then know its size. And you can use that then in multiplexing as the limit. In this case, it's ETFC 4. And my lords and my lady can see the multiplexing step, which is step 3, up to, but not exceeding that size. See the text, not simply multiplexing each category in accordance with its grant. There's this additional limit using the ETFC that's been identified before multiplexing. And in this case, in exactly the same circumstances, with the same grants and the same ETFCs, that leads to the multiplex data being one multiplexing block smaller. One smaller than it would have been using the pre-existing scheme. So, not necessarily a good idea if you want lots of data from that phone, but a good idea for the reasons that I've been explaining. Once the multiplexing is done, the next step is selecting the ETFC that's big enough to take the multiplex data. That's the same step as done in the price specification that one always does after multiplexing is complete. And in this scheme, it will often be the same ETFC that's selected was selected higher up, but it's not necessarily the case. There may be reasons that for somehow you don't use up all the space that would have been there. So you've still got to look to see what you've multiplexed and you choose the smallest one that works. But generally, you're going to be picking one that may have been used was used as the limit at step 2. And then the last step is the same. You have to fill it up with padding. You add the padding. But in this case, the result is a smaller MAC-E PDU sent in that smaller ETFC. And you can see from the legends that are on this diagram, because this is a modified version of Dr. Irvine's diagram, he liked to call these regimes as round up and round down respectively. Now, there are two important notes.
And it looks as if you've got the same amount of padding.
Well,
Actually,
it looks broadly the same.
looks it.
Yeah, and actually one of the points that you can't tell in this diagram, it's not intended to say they're the same, it's just that...
Schematic.
Yeah. Two important points about this, as recorded by the judge. First, para 194. So I'm in the judgment on page 127 of the bundle. The actual ETFC selection step, selecting the ETFC that's used to send the PDU, had been omitted from Dr. Irvine's original diagram. And that's why it says step 3. Our correction was to put that in. Related to that is an important point made by the judge at 195B. So over the top of the page, the right-hand side of the diagram, so this is the patent, highlights the additional and earlier selection step, step 2. It's earlier because it needs to be done earlier in the procedure so that the size is used in multiplexing as the limit in the text to step 3 makes clear. But can I ask my lords and my lady to particularly note this? At para 195 little 2, this earlier step is what the patent scheme requires. That's what he says here. See, which the patent scheme requires, the second line down. That's the earlier identification of the ETFC size before multiplexing, which is then used as the limit in the multiplexing step as we've just covered. And please note it well, because it's that additional step that the judge looks for. He looks for that when assessing anticipation by filiatro in the earlier stage of his judgment. And it's the absence of that step which he gives as a reason that there's no anticipation. Here the judge is saying the patent requires this additional earlier step, identifying the ETFC that's smaller than the grants. And it's because at this point he's applying a construction that actually requires the application of a limit to the multiplexing step, the limit being the size of the ETFC, and you obviously can't do that unless you've identified it at that earlier point. As I say, we'll come back to it because we'll see the judge gives us a reason to reject the anticipation case in the earlier stage of his judgment, the absence of this. Now, can I just pause and explain that actually this was actually common ground between the parties as far as one could glean from all the material filed before the trial. Specifically, it was common ground between our side and Dr. Irvine, Lenovo's expert. I've given you a couple of references in my skeleton at paras 40 and 41 to illustrate this. And this is an important point because my friends attempt to argue that my construction wasn't advanced at trial and to argue that this is all new on appeal. I might add it's somewhat ironic coming from a party whose case flip-flopped all over the place at trial, as the judge, well, certainly the judge notes the changing case in paragraph 7. Let me show you the key bits. First, Dr. Irvine's written evidence. We've set out para 8.38 in our skeleton, paragraph 40. The actual evidence is in the supplemental bundle, and it's worth looking at in its context. So picking it up, it's at tab 10, picking it up at page 128 of the bundle, just before, so this is paragraph 8.36, right at the foot of the page, where I'm just under the heading the claims. He's explaining that he's setting out his understanding of the claims to assist in considering his evidence, which is not uncommon. Obviously, a matter of construction for the judge, but experts often have to do this, or actually don't know what they're talking about. And you go over the page to 837, you can perhaps just pick it up in the last few lines of 837, where this is after he's dealt with explaining the process of determining which ETFCs are supported. So that's the earlier stage of working out which ones are available. He explains in the last few lines that the mobile limits the MAC flow data such that the combined size, so it's an overarching limit, doesn't exceed the next smaller ETFC. That's the guts of what he's saying in those few lines. And in fact, he summarises it in A38, which is what we've picked out for my lords and my lady. He's identifying claim 1 as involving 3 steps. So he's looking at it as an apparatus embodiment of a procedure. And you'll see he says the first is identify a size of MACD flow data allowed by the grants. Basically add them up. Next, choose the largest ETFC that's smaller, i.e. identify the ETFC size that's going to be a limit. And the third is limit the MACD flow to fit that size. It's expressly saying exactly what my lords and my lady will understand is our case. His oral evidence was to the same effect. You can see the passage that we set out in paragraph 41 of our skeleton. I'm going to take it from the skeleton, if I may. And this is me, obviously cross-examining him. You see at lines 14 and 15, so what's been introduced is a new multiplexing limit. That's the first aspect of what I put. And identifying the multiplexing limit, we use an ETFC size. That's the second aspect. And that's derived from a volume which is the sum of the grants. You can see I say we go to the next smallest. So that's the third aspect of what's put. And he agrees. Lines 19 to 21. Before we move on, can I just make good the point that I made earlier that the judge was applying this construction to? You've seen where he says it was required, and I promised you that you'll see him looking for that as a reason to reject the contention that Filiatro anticipated. So what I'm now addressing are the points I make in para 37 of my skeleton. So I'm in the earlier section of the judgment. When I say the judge applied it earlier, I'm in that section, paragraphs 254 to 301, so pages 140 to 153. And perhaps the most convenient thing to do, it actually goes back even further because there was a dispute on what the prior specification meant. So it probably goes all the way back to the debate about X3. But the most convenient thing to do is first pick it up at the summary paragraph at the end of this long section. So paragraph 300. The judge is summarising his view on three questions that he'd actually identified as key back at para 199 on page 128. And looking at his answers in para 300, the first 2 points, subparas A and B, are points that go to how the prior specification, filio specifically, would be understood, Filiatro specifically. And the third, so having dealt with the key points about how it would be understood, the third is asking if Filiatro discloses that additional step. Step 2 on the right-hand side of X3, which he rejects. And it's that reason that the anticipation case is rejected. Plainly in my submission, concluding the earlier step that he specifically drew attention to when considering X3 and said was a requirement, plainly concluding it's not present, and as a result there's no anticipation. He said it, just to remind you, page 128, it's actually the same page where he sets out those three questions that he's actually answering. He said it in subparagraph B at the top of 128, the bundle. Yeah. And the questions that he formulated as being key is 199 on the same page. He's plainly applying a different construction and concluding no anticipation. Now, Mr. Abrahams contends that a different construction is not being applied here. He says, now let me get this absolutely right, this is skeleton paragraph 21, subparagraph 1. apparently this is the judge dealing with Lenovo's contention as to what was disclosed in filiatro on any construction. He goes on saying the judge was not finding or assuming that claim 1 was limited to that particular sequence of steps. Well, my lords, my lady, with respect, that's just not tenable, nor does it even make coherent sense. It's obvious that this additional and earlier step of identifying the ETFC at a stage where it can then be used as a limit in multiplexing was something the judge considered to be required. He said as much, as I've shown you, para 195b, and then para 300 gave its absence in filiatro as the key final point when rejecting the anticipation case. And of course, it's an important part of what the judge was doing is identifying the step as earlier, because it has to be used in multiplexing. So ordering is important, at least to that extent. We say it couldn't be clearer that the judge has plainly proceeded on the basis that this is a requirement and gave its absence in filiatro as a reason it doesn't anticipate. And it's not surprising. It's common ground, as I've shown you, between us and Dr. Irvine, at least. Nor do we, on this side of the court, even understand what my friend is talking about in paragraph 21.1 of his skeleton, where he says the judge is dealing with something that would fall within the claim on any construction. It obviously doesn't. We'll come to the detail shortly. Certainly on Lenovo's primary case, it requires it, and on mine, that earlier step of identifying the ETFC and then using it in multiplexing. But the judge's construction at the end of the judgment plainly doesn't, as we'll come to. So the key point here is that he was applying a construction that is consistent with the common position between the experts, consistent with my case, that the claim requires you to actually limit the multiplexing step with the ETFC size. And indeed, it's clear that my friend understands what my case is because he set it out in paragraph 20, little 3. That's what he's picked up on. Please note this at this point. This does not involve applying the next smaller ETFC size as a limit in a particular way. You don't have to do it in a particular way. I'll come to the different ways one may do it. But it does, in accordance with the level of the generality of the claim, require it to be actually applied as a limit to the multiplexing. Can I deal with one related point, which goes to my friend's case that this is all new on appeal? I've already shown you some of the material that deal fatal blows to that contention. His own expert had the same understanding, that I was ad idem with him in cross-examination. Shown you the fact the judge was applying the construction in the earlier part of the judgment. But let me deal with my friend's schizophrenia and his suggestion as to what my construction had been before this. When drafting paragraph 17 of his skeleton, my friend says my case was essentially the judge's construction. He knows he's got to say my case was something different, so here he says it was the judge's construction. He relies upon some paragraphs in our opening which don't support him, all the more so if you actually read on. I won't ask you to turn it up now, but if he does rely upon those passages in our closing, please make a note to read the whole passage through to para 248. The point I'm making here is he's saying my case was the judge's construction. Now look at paras 30 and 35. Para 30 first, please. It said our initial read was little 2 from the previous paragraph. Trying to say our initial case was in fact Lenovo's construction. Some mischief is thought to be made because we described the limit as overarching, and I've explained why I'm happy to maintain that description. If you go forward to paragraph 35, the same point is made again. You say my case earlier was Lenovo's construction. Which is it? Was I running the judge's construction or was I running Lenovo's construction? Well, the answer is obviously neither. Running the construction that I still run today, but I'm pointing to the fact that he can't even identify what he says I was doing as the alternative in a consistent way. I was running that which you saw myself and Dr. Irvine ad idem at in cross-examination. And of course, one point I do make, the judge's construction as such wasn't really on anyone's radar, because the point that's led to it wasn't in any of the materials prepared for trial.
Wait, when you say the judge's construction, what do you mean?
Well, the end of the judgment.
Right, in the final DX.
Yeah, that's what I said earlier on. I'm going to stick to those labels, even though in my case is the judge applied a different construction earlier. I mean the one at the end.
Just so that I've got this clear in my mind, you say that the patent in suit requires the selection step every time. The standard may or may not require it, but the patent in suit does.
Not every time. What it requires you to do is the procedure is a procedure that has that step of using the next smaller ETFC size as a limit.
Yeah.
So if you do it in one TTI, you've infringed the method claim, and if you're doing it through program logic that does it, you have the means, so you infringe the apparatus claim. My case, in fact my friend's case, he says, is that they're of equivalent scope. The judge, I'm going to explain what happened, but the judge has concluded that it's anticipated in a procedure that doesn't have that limit at all. Simply if doing something else could lead to an ETFC which is of the same size that you might have ended up with. So by applying different rules, he basically says it covers everything unless they guarantee that it's always bigger. The point about whether you can opt out in individual TTIs is a temporal thing as to whether you're applying the procedure or not. And I'll come on and explain why that is. But the key thing is, if you think of it as an apparatus claim embodying a method, the key thing is the method has that step of applying that rule or that criteria. And the apparatus has the means that does it. You don't have to do it every TTI, but it has to have it. And when you do it, I've said this already, but when you do it, you ensure that the larger ETFC is not used. And the point I was just on is trying to answer my friend suggesting that I was running a different construction, and I'm only saying this now on appeal, and I've hopefully shown you that the judge was saying it in the earlier part of his judgment, the expert was saying it, and he's not even consistent, my friend is not even consistent with what he says I was running instead. And the point I was just making, I think I may not have made it, is just point out that the judge's construction, that one right at the end of the judgment, wasn't actually on anyone's radar at all, because none of them, it just didn't come into the case until, well, I'm going to explain how it happened, but the experts didn't treat the claim as meaning that at all. And I'll turn now, if I may, to how it came into the case. This is the topic of DXX14 and how it emerged. What happened at trial is a further modified version of the kind of diagram we were looking at in X3 was prepared by my learned friend and put to my expert, Mr. Townend, in the course of cross-examination. I said there was no hint of this as a point or construction underlying it before. And the document is called DXX14 because it was the 14th of the cross-examination documents. And we've reproduced it at paragraph 51 of our skeleton. And just for my lords and my ladies' note, it's at tab 8 of the supplementary bundle as well. And what this is illustrating is the prior specification. So filiatro, the prior specification, it's the same thing as we were looking at on the left-hand side of X3 in terms of steps in the procedure, but in a set of circumstances which is a special case, as I shall explain. So it's left-hand side. The earlier step that we saw on the right-hand side that the judge said was required by the patent is not present, i.e. that prior to multiplexing of identifying the ETFC that's then used as the overall limit on multiplexing. As I've said, the steps are exactly the same as the left-hand side of X3. So what's the point of it? Well, it's to illustrate a special case, which is this. You need to note that the circumstances are quite specific and different to that earlier diagram of Dr. Irvine's, created to illustrate the generality of the scheme. And what's been done by Mr. Abrahams for his cross-examination is to place the dotted red line, so the amount of data that the totality of the grant happens to provide for, very close to, just a little higher than an ETFC size. You see that? Quite close together. And they have to be that way round. And the point is this. By following the pre-existing scheme as it stood in the prior specification, one can multiplex without the step of ever identifying an ETFC or ever using it as a limit by using the bog standard individual rules of the grants separately, each separately applied to their respective category. And in this particular circumstance, you can end up with the body of multiplex data as illustrated here. It will depend on the size of the multiplexing blocks. But to cut to the chase, the point is the body of data multiplexed in accordance with the regime simply applying the grants, i.e. the pre-existing regime, may end up with a smaller, with an ETFC that's smaller than, sorry, I've stuffed that sentence up, let me get that right. Multiplexing in accordance with the grants using the pre-existing regime may end up with a body of data that is smaller than an ETFC, that itself is smaller than the number one would get if you added up all the grants, i.e. the dotted red line. Can happen, obviously without having to add the grants up at all, as I pointed out when looking at precisely these steps in the context of the left-hand side of the earlier diagram, and certainly without identifying that ETFC highlighted here, it's ETFC 4. And obviously without in any way deploying that size as a limit to the multiplexing process. There's simply no earlier step of identifying it or using it in the multiplexing. The thing the judge said in that earlier part of the judgment was required by the claim. And as you've seen, the thing he looked for when deciding filiatro was not an anticipation. What Dr. Irvine understood was required. So the basis upon which all his evidence was given. It's not here. Put shortly, without limiting the multiplex data to the size of that ETFC, in fact, without any limit to the multiplexing step as a whole, something I've referred to as an overarching limit, one can, in specific circumstances, just end up with a body of multiplex data that is smaller than the relevant ETFC. Or to put it another way, it's within it. without ever having been limited by that size. It's important. It's within it, without ever having been limited by that size. Let me pause and note 3 important points about this. What this shows is that on occasion, which cannot be controlled or predicted, the body of data could end up as the same size as it would do if one applied the limit of the invention. But of course, I hope my lords and my lady understand that I say the invention is about applying the limit. So without applying the limit, we can on occasion end up with the same Mac EPDU, same size, and the same ETFC. It's perhaps why Mr. Abraham started to become allergic to referring to the scheme as round up. Although that's the generality of it, his focus shifted. Second, perhaps related to that, this, what we've just looked at, is not limiting it to the relevant ETFC size. It just happens from applying different rules. And it is noteworthy that Mr. Abraham shied away from suggesting that the device operating like this therefore had means to limit the multiplex data to the largest ETFC size that's smaller than the sum of the grants that the claim requires. Instead, he rephrased it as to be within. Let me show you that. The cross-examination set out in paragraph 317 of the judgment at the end. So I'm back in tab 8. And this is the paragraph where the cross-examination concerning DXX14 is set out by the judge. Foot of the bundle, page 156. And you see the crucial thing is the last question on the page is obviously referring to the mobile's application of the grants and referring to that as limiting. But it's to be within. See in the penultimate line? One might have thought that the next question would have been to suggest that it therefore had means to limit to the ETFC size. But he dare not ask that question because he knew the answer he would have got. The mobile hasn't limited the multiplex data to that particular ETFC size any more than any other thing that happens to be bigger. For instance, all the other ETFC sizes that are bigger. It's simply something that happens as a result of different rules without applying a limit at all.
And do I understand correctly, you also rely upon the carefully qualified answer by the witness, who says, in this particular case, by virtue of where MAC D PDU sizes and the particular grants that were being assumed, yes. Yeah, he doesn't say yes because a limit has been applied.
Well, no, and indeed I suspect, recalling the cross-examination, the witness was waiting for the next question, which would have been, therefore it has means to limit it, and he would have squashed that suggestion. But wisely, cross-examiner didn't go there because he knew he wouldn't have got the right answer.
Yeah.
So it's essentially what you say is this outcome happens because of extraneous circumstances and not by virtue of any means for limiting.
Yeah, exactly. Exactly. And I'm going to come on and explain that really what's an issue here is a kind of undistributed middle point. We say that the invention, when you apply it, ensures that an ETFC that's bigger isn't used. And what he's trying to say is that unless you can ensure that an ETFC size that's bigger is used, everything else is within it. And there's obviously all those procedures that don't ensure one way or the other. It just happens because of the application of different rules. But I'm jumping ahead, but my lord's got the point.
So you're not just saying it's happenstance, you're saying it might happen, but it might happen as a result of the application of different rules.
Exactly, and the invention requires the application of this limit, that's the method claim, and the apparatus is the means to apply this limit. That's what matters. And the third important point is this. The invention, as I've said a couple of times already, ensures when you use the procedure that an ETFC larger than the next smaller one is not used. All this shows is that in the old system, sometimes it happened, but you weren't ensuring it. The prior scheme does no such thing. It doesn't have that earlier step the judge identified as required, which when you identify the ETFC and then you earlier, like the judge identified, and then use it as the limit on multiplexing, you ensure that a larger ETFC is not used. It's just the prior scheme doesn't ensure that the bigger ETFC is always used. That's the point. That's the only point you can make out of this. I'm saying that the invention ensures that the bigger one isn't used. And really all this is an answer is say, but the old scheme doesn't ensure that the bigger one is always used. The invention is about having a procedure with that new multiplexing limit, applying the size of the next smaller ETFC, thereby ensuring that the mobiles operating in accordance to that new scheme contribute to increased efficiency because it ensures that they don't use an ETFC that's bigger. And as I've shown you, my friend agrees that the invention's about ensuring this. He's running a case where the claims extend to a mobile device running a procedure that don't do so. The system and procedure he says is within the claim doesn't ensure that a bigger ETFC is not used, and indeed gives no improvement over the scheme of the prior specification that it's intended to be an improvement of, because he's saying it covers it. Can I pause and just make a couple of points about this? First, he's well aware of the lacuna he's seeking to navigate. Can we please look quite carefully at his skeleton at paragraph 26 and 27? We've looked there already, but I want to look again, please. He refers to what the patent is directed to, commending both our expert's description and our skeleton, as I've already drawn my lord's and my lady's attention to. Specifically, paras 30 and 58 are called out, including the sentence that explains that the invention ensures that an ETFC larger than the sum of the grants is not used. The footnote explains that leads to less padding. Before I show you the next paragraph and the linguistic sleight of hand, can I just ask my lords and my lady to pause and address this? He agrees less padding and an increase in efficiency. Less padding than what? An increased efficiency over what? Well, the answer is, of course, less padding than the prior specification scheme, and an increase in efficiency over that scheme. It's a trite point, but it's worth making because the judge's construction covers that prior specification and provides no such reduction in padding or increase in efficiency. Obviously the same, because on the judge's construction it covers it. Can I ask you to look at the next paragraph in my friend's skeleton, read it with what we've just seen in paragraph 26 in mind. So remember, my friends agreed that the invention is about ensuring an ETFC larger than the sum of the grant is not used. He makes the point that the invention is directed to what's sent over the air and has nothing to do with any particular procedure to achieve the result. Reiterates that point. Says the reader wouldn't think that the patentee intended to limit their claim to any particular procedure. We agree in this sense. How one applies the multiplexing limit of the particular ETFC size is not a requirement of the claim. The level of generality of the claim is simply that one does so. And as I shall show my lord and my lady, the patent actually has different ways one can do it in the examples. One might have thought that the next step in the logic would be to say that any means which ensures that an ETFC larger than the sum of the grants is not used is within the claim. Because he's just agreed that that's what the invention is about. And you'd have thought that you'd be using the same language, but he doesn't do so. He very carefully argues that one would want to claim any means able to produce the result that an ETFC larger than the sum of the grants is not used. The language has changed. Although the invention is about ensuring that an ETFC larger than the sum of the grants is not used in mobiles operating it, he says at the end of the paragraph, tellingly, one think that the patentee would claim any means able to produce a result where an ETFC larger than the sum of the grants is used. And of course the key point is he's saying the patentee has covered schemes or procedures which are not concerned to ensure that mobiles using them don't use an ETFC larger than the sum of the grants. It's enough if on occasion that happens. If on occasion it can happen, they're in the claim. So that's the first point to note. There's a linguistic sleight of hand going on here where the language changes between those paragraphs. In fact, it goes a bit further than that because he suggests that then there is the benefit of less padding. See, right at the end of para 27. You should think about that quite carefully. Less padding that we've been talking about is a benefit of across a population where one ensures the ETFC larger than the sum of the grants is not used. For any individual instance, one cannot say less padding is or is not used one way compared to the other. And indeed X3 is pretty good at showing that because it's not possible to say which way round it is, as my lady pointed out. For any individual instance, you can't say, but statistically, you can. And so what's going on right at the end of this paragraph of my friend's skeleton is he's gone to the position of considering individual instances. But the benefit of the invention is a statistical efficiency across a population, across time, as my friend has agreed. And I've shown you that in paragraph 31 of his skeleton. Now, the next point to note at this stage is that what my friend is really saying is not that the claim covers all mobiles running a procedure that ensure that an ETFC larger than the sum of the grants is not used, but he's actually saying it covers all mobiles running any procedure unless they ensure the opposite. In other words, they're covered unless they ensure that an ETFC larger than the sum of the grants is used. I've got to the stage in my note when I want to introduce the non-infringement point that the judge considered to have an impact on this argument. So can we just identify that because the judge thought that it was of some significance to the DXX14 point. And my lords and my lady, I think, have got a flavour of it because we've foreshadowed it a bit already. It's this. When I explained the CDMA system where transmission power equals noise or interference, I mentioned that the individual transmissions took place in small time windows called TTIs. Each of the populations in a phone, sorry, the population of phones in a cell makes a transmission in that very small interval. And then in the next TTI, the whole thing's done again, and another transmission is made by each of the mobiles. And in fact, that's the point of the system of grants, as I foreshadowed a little bit earlier, is that for each TTI, particularly with the scheduled grants, you can redo the allocation TTI by TTI. Now, what the patent is describing and claiming is obviously the procedure that's carried out in a TTI. And one of the arguments Lenovo ran at trial, and indeed they do in this court by its respondent's notice, its primary case is an argument that the words means for in claim 1, followed by the description of the limit to be applied to the data multiplexed, import a requirement that the mobile device must do it again and again and again in every TTI. Put shortly, there must be no possibility of a mobile ever opting out in any TTI. It must carry out the procedure repeatedly. My lords and my lady will understand that I say that what that means is it's got the means to do it and an extra requirement that it must do it every TTI. And obviously we say the claim doesn't require that. But now at trial, the point was put as a point of construction of the words means for, but interestingly said to provide a non-infringement argument across the board. And I think it's still my friend's case that both the apparatus claim and the method claim have equivalent scope. That's what he says in paragraph 52 of his skeleton. So I think he still says that this point gives him a non-infringement point on the method claim and the apparatus claim. What he was doing at trial anyway. Let me show you how the judge dealt with the issue. You need the judgment, so I'm back in Core Bundle tab 8, page 125 of the bundle, at para 181 to 184. And you see the heading means for, which is reflecting the fact that the point is advanced as a point of construction of those words. My lords and my ladies see the judge explains the argument in para 181 that the means must operate all the time, and our conventional riposte is set out. The judge explains the point of the argument from Lenovo's point of view in para 182, how it gave it a non-infringement argument, because in the standard, when a mobile only has non-scheduled data, the means are not deployed. So Lenovo argue the claim requires deployment again and again and again in every single TTI without exception. Hey presto, no infringement. And the judge rejected the argument at 183. Importantly, he also noted that even if he assumed the argument worked for claim 1, that's the apparatus claim, it would not work for claim 5. The method claim, as Lenovo would be responsible for multiple infringements of claim 5. The method equivalent of claim 1. It even says here the method equivalent of claim 1. Can I just pause here and make a couple of points?
If you use the method claimed in claim 5, does it follow that you have an apparatus with the means to do that?
In my submission, yes, because that's the correct construction of this patent. It must always be a proper, the point must always be a question of construction of the claims. But it must be so on this case, because this is basically an invention that's a procedure. We'll see when we get to the patent. That's what it says on the front. And you would understand that this claim is an apparatus equivalent of a method. And the judge here is saying that that is so. Mr. Abrahams says that the claim has the same scope, their equivalents. I think it's paragraph 52. Says the claim does not and cannot have any materially different scope from claim 1. We agree. But when we get to it, you'll see that he's fighting tooth and nail to stop any reference to claim 5. Because although he says it means the same thing, he knows that when you start looking at it, it can't on his construction. But my point, my lord, here is that the judge is saying, even assuming Mr. Abrahams was right on claim 1, it obviously isn't a construction that would work for claim 5, because that is pitched at a method which is a per TTI method. And we say that the apparatus claim is simply pitched at apparatus that has the means to apply those steps per TTI or not. But the judge is recognising that it wouldn't work.
Crunch comes at 184, where he says the finding has consequences because integer 1f is expressed in broad terms. It is satisfied by any means which bring about the stated result. Now, do I understand your argument correctly that there's a latent ambiguity in that phraseology?
Well,
because you would agree with the judge's statement if the words bring about are read as meaning ensure. Means which ensure the stated result, you would say that's absolutely bang on.
if you put it that way, or the other way of looking at it is, it depends what you mean by the result. If the result is you end up with a PDU of a particular size, no.
Yeah.
If the result is you apply the limit of the claim, yes. Yeah. And that's the way I put it. But broadly, obviously the sentiment that just says means for and then there's something described isn't limited to a particular narrow way of doing it. In essence, I'm agreeing with my lord. I do put it, and will when I get to it, a slightly different way, in that it does depend on what you mean by the result.
Yeah.
The result is the application of the limit in my submission, not the ending with a PDU that happens to be something that's the same as you might have done with a different method.
I'm always trying to search for real, analogies in the real world. But you probably told me this is no good either. But if I set cruise control on my car to 10 miles an hour below the speed limit, so I can't go more than 10 miles below the speed limit, I could achieve that result by simply not accelerating quite so hard, but I'm not using the method of getting there.
Yeah, indeed. You could that is even my note's got an example of restricting access to a fairground ride by limiting height. You can have a bar. I wasn't intending to go to it, but I've been thinking along the similar lines. You could have a bar that someone has to walk under, but that doesn't mean that somebody that's lower than that height that gets on the fairground has been limited. It just happens. Your limit might simply you've got to buy a ticket, but it's the application of the limit or the rule is what matters, because that ensures that the opposite doesn't happen. Just showing that you end up occasionally with a result that you might have got when you didn't apply the rule is not good enough. Now, this section of the judgment is obviously important because it shows that the judge is thinking that there's a bit of a squeeze here when in fact there's not. But it's also important, 183, for dealing with another
problem. Sure, I've understood that. So can you just explain again why you say there's no squeeze?
Right, there's no squeeze because the The argument about construction of what the claim requires is for you to actually be applying the limit. So you have to have a procedure that in a particular TTI, when you're applying it, does apply the limit. So in order to infringe the method claim, there have to be TTIs when you do apply that limit. And in order for the phone to infringe the apparatus claim, it has to have the logic in it that can do that, which when deployed, do apply the limit. What the squeeze that the judge thought there was is that even when you don't apply the limit, if there are circumstances where you end up with the same size PDU, you end up with circumstances when there's the same size PDU, that's within the claim, unless you also read into the claim the requirement that you have to apply the method every TTI. They're two separate things. The requirement of having to apply the rule every TTI and the requirement of having to apply the rule at all. And when I come to set out the constructions, my construction is the requirement to have to apply the rule, so you need the means and you need to apply the rule. It's just you don't need to do it every TTI. The judge's construction is you don't need to apply the rule at all, and Lenovo's construction is basically mine, but you have to apply the rule every TTI. Now,
All right, can I ask a different question, which you will come to in due course? And I'm going to ask the question now, not necessarily so that you answer it now, but just so as to make sure that you answer it when you come to the relevant point, which is, it's another way of putting the question that my Lord Justice Lewison asked a little while ago, which is, we can see from the skeleton arguments, as you've said, that it's always been common ground, and there's still common ground, that the method claims and the apparatus claims have the same scope. But the question I'd like to ask is, what if the common ground is wrong?
right.
And what if actually, upon a true construction, and bearing in mind that the court is not constrained to construe the claim in the way that the parties agreed,
Yeah.
if the court thinks that that's wrong,
Yeah.
construction is, at the end of the day, a matter for the court.
That-
What then is the consequence of that? Because it could be said that the only reason we've got into this hole is because of an undue focus upon the apparatus claims, and that the analysis is actually a bit simpler if one concentrates on the method claims.
True. What I'd say about that, my lord, is that the likely way in which you would end up concluding what's happened below is that everyone's treated them as equivalent, so that the apparatus is an embodiment of the method claim.
Yeah.
So they've actually been focused on the substance of what the method claim is. And I think what you're putting to me is, what happens if you decide that the apparatus claim isn't actually that?
Well, because when you view it through the prism of the apparatus claim, at the end of the day, the vital question is the interpretation of two words, means for.
Sure.
But those two words are not present in the method claim.
Exactly. That's one of the points that I make about the non-infringement point is advanced as a point of construction on words that aren't even in the method claim.
Yeah, and the judge says that at 183.
That's exactly the point. And in fact, one of the points that I mustn't forget to deal with it, because my friend tries to say we can't rely on Claim 5 because we never mentioned it at trial, but you can see here that we did.
Yeah.
And I'm mentioning it and relying upon it at trial for this reason, because I was arguing that Claim 5 and Claim 1 were basically the equivalent. The apparatus was the equivalent of the method. You saw that a little bit earlier where the judge was saying the same. And when my friend put forward an argument that was inappropriately wide, or inappropriately narrow, I can rely upon that point to say that doesn't work for the method claim. And that's what, this is an example of where I did it.
Yeah. So you say, as I understand it, given that it's common grounds that the method claims and the apparatus claims are of the same scope, one way of analysing it is to look at the method claims first, or at any rate use them as a test or a cross-check upon your construction of the apparatus claim.
Absolutely. And when you get to the patent, it says that it's the invention's a procedure on the front of it. And it is, the substance of the invention is a procedure.
All right. So I just thought it might be useful to get that out now, but I've slightly diverted you from where you were going next.
No, not at all. I think I've just actually said what I was going to say next in my note, which is that we plainly did rely upon the claim 5, and our argument is the same in this court, that we contend that the construction of the apparatus and the method claim are the apparatus and method equivalents, as indeed the judge said. And we do the same here. We also say, as an aside, this answers the rather inconsistent argument that my friend makes in paragraph 54. After having said that no reference was made to paragraph 5, he then seeks to say that we're doing so here in an inconsistent way to the way we did before the judge, which is obviously inconsistent on his part because he's suggesting we didn't before the judge. It isn't inconsistent to basically say that in substance the invention is a procedure or a method, and you can look to the method claim on any instance where an inappropriately wide or an inappropriately narrow construction is being advanced. And that's exactly what we do on Lenovo's construction and the judge's construction. One is inappropriately wide and one is inappropriately narrow. And there's nothing inconsistent about saying, hang on a minute, this is in substance and would be understood to be a claim to apparatus embodying the method. One further point that I make in relation to this claim 5, claim 1 point is I've shown you that my learned friend actually says that his case too is that they have the same scope. That's his paragraph 52. But why is he fighting tooth and nail to stop my lord and my lady looking at claim 5 to assess whether their submissions fit with that position of equivalent scope? Well, it's because when we get to it, you'll understand that his submissions are absolutely hopeless when it comes to the method claim. And indeed, as I understand it, there's no real attempt to even explain how the method claim could possibly work with his submissions. But anyway, that is the non-infringement point, that it must happen each and every TTI. It was put forward as a non-infringement point, as you see, dismissed, but the judge, as my Lord Justice Arnold has focused on, the crunch point is paragraph 84, where he says it's going to have consequences.
184.
Sorry, 184, yes, and the consequences are the DXX14 point. I think I've, in answer to my Lord Justice Arnold's questions about why there's no squeeze, covered what I'm just about to address, so I'm going to try and take it more quickly. The point of construction here is a temporal one, meaning it's a point that is directed to whether it has to happen in every TTI. The point on the DXX14 point is an argument about whether you have to apply the limit at all. That's why there's no squeeze. It's been a long time coming, but now can I turn to the patent itself? It's, I think it's in the supplemental bundle. tab 2. Its title is Mac Multiplexing and TFC Selection Procedure for Enhanced Uplink. So it's expressly focused on a procedure for enhanced uplink, what actually became known as HSUPA, High Speed Uplink Packet Access. And the procedure is for the Mac multiplexing and the TFC selection. Because the Mac entity became called MAC-E, E for enhanced, and the TFC specifically became ETFCs, that's what it's about. MAC-E multiplexing and ETFC selection. So its title expressly identifies it as a procedure concerned with those matters. Before we look at the claims, can we look at some of the variety of the specific ways illustrated in the patent embodiments? Because both my friend and myself rely upon the fact that there are various ways in which the multiplex data may be limited to the size of the next smaller ETFC. My friend relies upon it, for example, in paragraph 28 of his skeleton, where he says there are a variety of specific methods. And he's right. If I may, I just want to pause on that, because you've seen that we rely upon it, particularly in our reply skeleton. And I think you'll be able to see that using the size of the next smallest ETFC as a limit on the data could be done in a variety of ways. One might reduce the allocation of a grant applicable to an individual MACD flow by the amount that the ETFC size is below the sum of the grants. So just take a really simple example. Assume the sum of the grants is 100 and the next smaller ETFC is size 90. One needs to cut back by 10, and one can adjust, just say, the scheduled grant or allocation down by 10. So the sum of the grants is now equal to the size of the ETFC size of 90. One might consider doing much the same to another grant to achieve the same effect, or you might adjust 2 or more grants in the example that I've been talking about. And if you're doing 2 or more, you could adjust them to the both to give the combined reduction to 90. And when doing that, there may be details of how you do it, whether you do it 50-50, so a reduction of 5 from each, or some other way, perhaps in proportion to the size of the allocation. One might consider doing other things. Data has characteristic other than whether it's scheduled or non-scheduled, a characteristic known as its priority, and one can understand from the name that it's basically how important it's treated. So one may decide not to apply the limit by reducing a particular grant, but simply to multiplex in order of priority until no more can be added without exceeding the size of the ETFC ones identified. There are more complicated approaches that you might think of, adjustments that might depend upon how much data actually gets multiplexed in during the process, so that reductions in the grant itself reductions in grants can themselves be adjusted during multiplexing if some other grant doesn't get used up entirely because of the mismatch in the size of the grants and multiplexing blocks. There's all sorts of things that you might do. There's a potentially large and increasingly complex way of the basic idea of identifying the relevant ETFC size and then using its size to limit the multiplexing step. And my submission is that the claim isn't limited in any way to one or other, or even a collection of those ways. What's important is the generality of the level of generality of the claim. And the level of generality of the claim requires the ETFC size to be used as a limit, but not any particular way. And consistent with that, the patent itself sets out a variety of ways in which this is done. And I just want to show you a couple of the simpler ways. Some of the longer figures are getting into the more complicated ways that I alluded to, but just a couple of examples. The first is figure 4, which is on page 45 of the bundle. It's it's the basic scheme of adjusting, or to use the patent's language, quantizing one or more grants. You see the first box, 405, is receipt of the grants. The next is identifying an ETFC size based upon the amount allowed according to the grants. And the third is quantizing the amount of scheduled or non-scheduled data, in other words, adjusting one or other of the grants. A point to make about this particular example and about the description in the patent in general is that the detailed description in the patent was directed to either making an upward or a downward adjustment, so limiting to the next smaller or allowing to be more closely matched to the ETFC that's next bigger. Both could have the effect of making sure the padding is less than the size of the multiplexing block. And as my lords and my lady know, the claim has been restricted to the case of limiting down to the next smaller. But that's why the language here is more general, in that the ETFC is selected based on the amount of data by the grants. It could have been the next bigger or the next smaller in accordance to the general description. But of course the point is that the ETFC is being selected and used in the process, in this case to adjust the grants either up or down in the generality of the scheme, but when you know that you've got to go down, it's used as a limit in accordance with the claim.
So your essential point is that you select the ETFC transport block before you aggregate the data.
Absolutely. And that's why the judge says it's an earlier step. When he's looking at X3, right-hand side, what the claim requires is that earlier step of identifying the ETFC so that it can be used in that multiplexing step. So my lord's absolutely right. That's my essential point. It's one of the simpler ways, but as I say, it was pitched at a level where it could have gone up or down in the generality of the description, but it's been restricted to going down in the claim. Figure 6 is another example. So that's page 46 of the bundle. It's a flow diagram. It's another one of the kind that I mentioned. This is one that's specifically downward, always was, so it's only ever going down, limiting to the next smaller. And it's one using the priority rules, so using that other characteristic that data has, and simply stopping when one cannot add more without exceeding the ETFC size. And my lords and my lady can see the first thing in the flow diagram, box 602, identifying the ETFC that's next smaller. So doing exactly the same thing that my lord just drew attention to. You do it first. It's the largest that's smaller, so that's the wordy way of saying next smaller. Box 604 is multiplexing, and one sees the simple point is you stop when no more data blocks can be added within the limit of the ETFC that's been selected. So it's applying that size as a limit in multiplexing. We see that it's basically the basics of how you apply that size as a limit. And what the case really boils down to is this. One can require that to be done. One can require that the ETFC that's next smaller and then is used as a limit to be done, which ensures that the larger ETFC is never used, which is what the invention does, and require that without requiring a specific way to do it. And that's really the fight between us, because my learned friend says, well, you must be requiring a specific way. But I'm not, and as I've already said, the level of generality of the claim, what the claim is requiring is for it to be done, but not a specific way. And the fallacy in my friend's argument is to suggest that if DXX14 is not covered, where it doesn't get used at all as a limit, I must be advancing a case that the claim is limited to a particular way. That's the fallacy. And I'm not. I'm in that middle ground of requiring it to be done without requiring a particular way. Now, can we turn to claim 1, which is on, actually back a bit, on page 40 of the bundle. It's in the form of an apparatus claim to a wireless transmit receive unit, and we can take that as a mobile device such as a phone. But consistent with the fact that the essence of the invention is a procedure, all the integers that relate to the wireless transmit receive unit are framed as means for and then words describing different steps in the procedural method. And it's not just the one that we're concerned with. There are three. There are three such steps set out in this claim as means for. And do note that, because that does have an impact when my learned friend starts running an argument that means for just means suitable for, because it must apply to the other integers, if whatever he's saying. There are three steps. The first means for is at line 13, followed by text in the next 6 lines, which describes the step of receiving the grants. And there's got to be at least one scheduled and at least one non-scheduled. The next is at line 21, where we see the second means for, and that text is down to line 26, is the step of determining which ETFCs in the set are supported, so determining what are available to be used. So you have to knock out the ones that are not available. It's a point that I touched on with my lady earlier. And the third and final means for, at line 27, is followed by text which describes the step of limiting the MAC-D flow data that's multiplexed into the MAC-E PDU to a largest ETFC that is smaller than the size of the data allowed by the grants. So limiting it to the ETFC that's the next smaller. Rather wordy, I've been using next smaller to mean that. And claim 5 is the same 3 steps expressed as a method. It begins at the bottom of the same page. It's a method of multiplexing data in a WTRU, but otherwise it's the same language. The 3 steps are set out on page 41, left-hand column. As I say, we say the scope is equivalent. The judge referred to them as equivalent, para 183, and my friend professes that his position too is that they're equivalent. Now the judge...
Sorry, before you go on,
Yes.
you touched on, in going through claim 1, a question about the meaning of the word for. And I'm a little bit puzzled about this aspect of the case, and it may be that this is more a question for Mr. Abrahams than for you, but nevertheless, I'll ask you in the first instance, which is this. At the moment, as I read paragraph 104 of the judgment, the judge did not interpret the word for as meaning suitable for, he interpreted it as meaning adapted for. And you say that's correct in this context. But I don't understand Mr. Abrahams to be challenging that. If one looks at his respondent's notice, tab 2 in the core bundle, page 19, he says in the alternative to the judge's construction, he could also have held the means for ensuring that the MAC-D data flow multiplexes could not exceed the stated limit, etc. So therefore, doesn't cover a device in which it could be, and on that basis is valid but not essential or infringed. So, in a nutshell, he's not challenging for as being interpreted as adapted for. Rather, he's saying if you go down that route, it leads to non-essentiality and non-infringement.
I think my lord's right about that. One of the peculiarities about all that material right at the front of my learned friend's skeleton is that truly is all new. We didn't have any suggestion that it should be suitable for, and the judge didn't approach the claim as meaning suitable for. I've already told my lords and my lady that I intended to deal with that issue last and briefly for this reason.
Well, by all means, come back to it later.
No, I'll answer the question now, but I was going to deal with why that's wrong, but I think now my lord's asking a slightly different question about the judge didn't deal with it on that basis, so it's a slightly different point.
Well, I think the question for you is a simple one. Do you agree that the judge interpreted for as meaning adaptive for in the apparatus claims?
Yes.
And am I right in saying that you say he was right about that?
Yes. He just, what it was for, he's got wrong, but
Yeah.
it's adapted for, not suitable for. It was never even raised that it should be suitable for. As I've already foreshadowed to my lords and my lady, the suitable for argument is obviously contrary to his primary case. Secondly, it doesn't even support the judge's construction, not least for the reason that my lord identified, but also a further reason in that suitable for obviously means it never actually ever has to do whatever the thing is. That kind of construction. The judge's construction was that he found that he misunderstood what the thing is that it had to do, but he found that it did happen occasionally. So it doesn't even support the judge's construction. It's completely missing the point of every aspect of the argument in this case, and that's why I'm leaving it to the end.
All right, well, why don't you come back to it then?
I think I've just identified the method claim with the same integers, and I was going to say, can we look at the simplified version of the claim that the judge set out? Having shown you it in its full glory, we can. It's in the judgment at 149, which is page 120. And he sets it out as, we're all happy with this more simplified version. He sets it out as 6 integers, 1A to 1F. 1A is simply the fact that it's a WTRU, i.e. a wireless transmit receive unit. The first 3 steps of the procedure, the first of the 3 steps of the procedure has been actually split into 3 integers, 1B to 1D. The second and third limbs of which separately describe what the 2 types of grant must be for. So all the way down to 1D is 1 step in the procedure, and the second and third steps are integers 1E and 1F respectively. Now, my own friend makes the point in his skeleton, this is paras 13 and 14, that it's integer 1F that matters, and that this was the only integer that was new over the prior specification or filiatro. We agree with the notion that this is the step that gives it novelty and inventiveness over the state of the scheme as it stood prior to InterDigital's contribution. But of course you have to have the rest as well, the receiving of the grants and determining which ETFCs are available. What the new step gives when added to the rest is an overall new and inventive procedure. And I make that point, although it's trite, because that points, it looks, particularly at the end of paragraph 13 of Lenovo's skeleton, as if he's trying to seek to suggest it isn't really a procedure, because what stands it apart from the old is just 1 step, or that the procedure is just 1 step. If he's going that far, he's wrong. The procedure is all 3, which is novel and inventive because of this step of integer 1F. Now, thus far, we've talked about what the rival arguments are on either side and also the judge's construction. Can I pause here and identify precisely what the rival constructions are? Because it's important that we know precisely how they differ. Given, my lords and my lady, a pretty good flavour, I think, but my construction first, so I'm going to address them in an order slightly differently to the order in which they've been addressed in writing. InterDigital's construction is that what is required, both in the apparatus and method versions of the claim, is this additional step of limiting the data that is multiplexed. So in contradistinction to individual grants, an overarching limit, and that the limit used is the size of the next smaller ETFC, i.e. next smaller to the sum of the grants. And just to unpack that, one needs to identify and apply the limit. The limit is the size of that next smaller ETFC. So you've got to identify it. That's the earliest step. And then you've got to apply it as a limit. It must be identified at a stage when it can be used in multiplexing. So before multiplexing, or at the very least before one's completed it. What is not required is applying that method, which includes that limit, applying that limit in any particular way. For example, one may choose to adjust one of the grants downwards to make the sum of the grants the size of the next smaller ETFC. We might adjust each of the grants downwards by some proportion, or something else more complicated along the lines we've been discussing. None of that is a requirement of the claim. My submission here is the level of generality of the claim. The level that it's concerned with is identifying the next smaller ETFC and limiting the multiplex data with that size. Not concerned with how you do it. And as I say my construction is precisely what we saw was the base upon which Dr. Irvine gave his evidence and what the judge was applying at the earlier section of his judgment. So my construction is the method claim. There must be a step of applying the next smaller ETFC size as the limit to the multiplexing. And in the apparatus claim, there must be means to do that. I might add as an aside, just like the other two steps covered in claims 1 and 5, those steps must take place and there must be means to carry them out. The next construction on the table is Lenovo's. This is exactly the same as my construction, but with the added requirement that the means must operate in every TTI. And as I understand it for Claim 5, they say the method must be repeated in every TTI without exception. So it is my construction with an added restriction of having to do it in every TTI without exception. My lords and my lady might have seen my friend seeks to say Lenovo's construction is different to the judge's construction because they construe the word limiting as meaning, or as really meaning limiting. That's para 18 of his skeleton. That's rather telling. It rather gives the game away that the judge's construction doesn't really mean limiting, and we'll come on and see why. But at this stage, what I should say is Lenovo's construction is more than really limiting. My construction is really limiting by the ETFC size. Mr. Abrahams says, yes, but you must do it without exception in every TTI. So Lenovo's construction is really limiting and never being able to do something else and opt out in a particular TTI if it's desirable. I was going to come on to the third construction, but I can see the time might keep.
How are we doing for time?
I think we're doing quite well. We've got. We've never planned to take all of tomorrow, but we were going to go into tomorrow. I'm getting quite close. Well, I should probably be about 30, 40 minutes.
All right. Fine. 2 o'clock.
All right.